D&O insurance policy, the principles for non-profit boards. Not too long ago, throughout a presentation to a group of non-profit board customers, I realized that some in the audience ended up not aware of the threats they faced as board customers. This posting clarifies why purchasing director and officer insurance policy is a necessary ingredient of just about every non-profit organization's possibility administration system. Qualifications. What responsibility does a board of directors have? The United States federal and state laws area the responsibility of making certain the purpose, programs and insurance policies of non-profit organizations on the Board of Administrators. To govern effectively, non-profit boards ought to be sure that the organization's mission, written in the article content of incorporation and filed with the state, is obtained and that the organization's programs and insurance policies are appropriate and staying adhered to. What is D&O insurance policy? Nonprofitrisk.org defines director and officer coverage as coverage that gives protection in opposition to wrongful acts which could incorporate real or alleged faults, omissions, misleading statements, and neglect or breach of duty on the component of the Board of Administrators and other insured people and entities. Many D&O insurance policies incorporate employment methods legal responsibility protection. Director and officer insurance policy may possibly address the cost of authorized counsel, out-of-court docket settlements, and court docket ordered payments. Without the need of this coverage protection, authorized expenses to defend in opposition to a legislation match could substantially problems your organization's funds or even pressure your organization into bankruptcy. Why is D&O insurance policy essential? All non-profit organizations ought to retain a current D&O coverage plan, and no just one ought to concur to serve on a non-profit board except if they are sure that sufficient coverage handles them for probable liabilities. If in worker, a member of the organization, a volunteer, a donor, or even another person from the standard general public thinks that the non-profit hasn't operated legally or according to its founding principles, they can sue the Board of Administrators. Defending in opposition to these costs can require high-priced authorized counsel, out-of-court docket settlement expenditures, or court docket ordered damages may possibly be incurred. Be aware, even if the costs are not valid, authorized counsel may possibly be essential to defend the board customers who are named in the legislation match. Scientific tests show that human resources relevant problems are the most frequent. Use of legislation suits in opposition to non-profit boards. This incorporates costs of illegal employment methods or negligence when choosing or firing workers, working with contractors, or taking care of volunteers. Other will cause of legislation suits incorporate conflicts of interest, not adhering to contracts, or applying donations for other than their meant purpose. Whereby can I get D&O insurance policy? Most coverage firms supply D&O coverage. Your state's non-profit support organization may possibly advise you on coverage carriers that offer non-profit D&O insurance policy in your state. Typically, the cost of a plan is centered on the mother nature and dimensions of the non-profit and whether or not authorized and/or settlement expenditures are covered. In addition, some insurance policies incorporate a lifetime extension, which gives protection to board customers even right after they have still left the board or the coverage plan has been cancelled. Most effective procedures for D&O insurance policy for your board. The treasurer of the board is usually dependable for finding an appropriate coverage plan for an organization. The treasurer ought to evaluate the D&O plan yearly to be sure that the protection carries on to be ample for your evolving organization. Search into employment procedures liability insurance policy when you happen to be wanting a D&O insurance policy. This coverage handles the non-profit for human resources relevant grievances, sexual harassment, discrimination, and many others, which are becoming extra common more than time. The bylaws of the non-profit organization usually state that board customers are indemnified, safeguarded from probable legislation suits, as long as they are attending meetings, paying notice to board decisions, and talking up when they are in disagreement with decisions. Listed here is in case in point bylaw that pertains to D&O insurance policy. Every director and officer shall be indemnified by the corporation for authorized charges in addition liabilities, fines, penalties and claims imposed upon or asserted in opposition to him or her, together with quantities paid out in settlement, except if he or she is judged liable for the reason that of gross negligence or ready misconduct in the efficiency of his or her duty as a director or officer. Include a dialogue of your D&O insurance policy protection in your board's annual orientation session. That is attended by all board customers. This dialogue ought to incorporate who is insured, the sum of the coverage protection, the cost of the plan, and the warning that board customers are not covered if they are not effectively engaged in the decision producing of the organization. Never shy absent from this concern. Forward this posting to your board's treasurer currently and talk to questions about your D&O insurance policy protection. Question that a presentation about your protection be created at the next board meeting. Make sure that you are insuring your organization in opposition to a legal responsibility that may possibly surpass your organization's asset worth. If you are a board member, make sure that you are indemnified as a volunteer of your organization.